That may.
Oh, sorry.
Okay.
Calling the meeting to order. Welcome back, everybody. Great to see everyone again. And I guess now we have to do a roll call.
When I call your name, please let me know if you are here. Francis Adewale,
Aye.
Tom Ahern,
Here.
Todd Bloom, Jordan Couch, Matthew Dresden,
Here.
Kevin Fay,
I think I'm here.
Christina Larry, Nam Nguyen,
Here.
Kari Petrasic,
Here.
Mary Rathbone, present, Serena Sayani, Allison Whitney, Brent Williams Ruth.
Here.
We do have a quorum.
So it's my distinct honor to present to you and introduce you to our presenters from the Limited License Technician Board. Welcome and thank you for being here. We have Chair Steve Crossland, Sarah Beauvais, and Christy Carpenter. This is not an action item. This is a report that the board very graciously offered to provide and present to us. And again, thanks for being here and look forward to listening to what you got to say.
Perfect. Thank you very much. And thank you for allowing us to come and speak. It's been a while and we thought it was appropriate for us to meet with you all and let you know what we are as a board and kind of give you some background. And again, we are intending no action, just information. We have about a 45 minute presentation, but we hope to leave enough time for everyone to ask questions, which we'd like to take at the end, if it's okay with you, so we can get through the presentation. So, but before we get started, let me tell you a little bit about myself and let my co-presenters give you some background on themselves. I'm a small town attorney in Kashmir, middle of the state of Washington, mostly office transactional things. I've sat where all of you have on the Board of Governors and in the President's chair. I think it's a wonderful organization. Obviously, you do too, and I'm glad that you do. I think you serve the organization well, and I appreciate the time you're taking to do that. So let me stop and turn it over to Sarah and Christy and let them introduce themselves. And by the way, they'll tell you, but I want to tell you as well, they're both LLLTs and frankly are exemplary models of our of the LLLT profession and among the earliest licensees in our profession.
Hi, I'm Sarah Beauvais. Thank you for welcoming us here. I'm in private practice in Bellevue. I was licensed in 2017. I have volunteered with Eastside Legal Assistance Program since I was licensed in 2017. I've served on the Low Bono Executive Committee. I currently serve this board and also the Practice of Law Board. No.
Oh boy, what a way to start it.
The perils of microphone. Hi, everybody. I'm Christy Carpenter. As Steve said, I'm a limited licensed legal technician. Before I became a legal technician, I was a paralegal for 22 years. I initially opened up my own law firm when I became a LLLT and decided that wasn't for me. And I'm currently with Pacific Cascade Legal in Tacoma. I volunteer with Tacoma Pro Bono. This is my 6th year on the LLLT board. And this is year 30 of my experience working in the law. So I don't feel old, but I feel wise.
By the way, as we go through this, you may see some of the lines highlighted in blue, and those are links to which you can go to further information about this. I presume you've all received this in their packet, so you can log in and get those. We're going to try to be brief about most of these. Some of them will be more in depth. So if it appears we're being brief with some of them, that's by design. So, and this one will be brief. When we began this license, or the thought of this license, it was based upon the civil legal needs study that the Supreme Court commissioned. We knew there was a big area of unmet need, and these are the areas that civil legal need study identified. And so those are the ones we focused on when we began the creation of the license. As you can see, we were the first in the nation, so we were sort of like Columbus going off into some unknown territory. But we think we had a good vision. And these are the things that when the Supreme Court adopted the rule in 2012, Justice Madsen wrote the opinion. I'm going to read these real quickly because I think she really captured the essence of what we think the license is about. And I'll read them real quickly. We have witnessed the wide and ever-growing gap in necessary legal and law-related services for low and moderate income persons. That's important because there has been some misunderstanding that it was only for low-income people. There is a huge, as the Civil Legal Needs Study identifies, a huge lacking of legal services available for people of moderate income. The civil legal system is unaffordable not only to low-income people, but as the 2003 Civil Legal Needs Study documented, moderate income people as well, as I just said. And the final one, which I really love Justice Madsen's characterization, we have a duty to ensure that the public can access affordable legal and law-related services and that they are not left to fall prey to the perils of the unregulated marketplace.
So the first LLLTs were issued a license in 2015. And as Steve mentioned, the license was really designed to concentrate on moderate and low income families and really moderate income families. And so what you see here on the slide is really a map of Washington along with the counties. This map was provided by the State Office of Financial Management. And what you can see is it shows what the average income is per county throughout our state. So if you keep moderate income in mind and look at the chart to the right, it gives you an idea of what those income level, like what is moderate income? What's the federal poverty line this year? And you know, how does that connect to our state? And I think what you'll notice is even in the dark purple counties on the edges of the state, most of those incomes still fall within the moderate income families for a family of four. When you get to the central part of the state, you're looking at the lower end income end of moderate income families. So this issue is relevant in every single county in our state, but especially in the central regions. The purpose, again, of the license was to provide qualified, regulated legal services providers at a price consumers can actually afford. The license allows LLLTs to provide legal advice and legal services in family law matters. So divorces, legal separations, domestic violence actions, and modifications of some of those orders. A LLLT can own their own firm by themselves or with other LLLTs. They can be an owner of a firm with an attorney. They provide services to government agencies and the court system, and they are also employed with civil legal aid providers. And when we're looking at kind of what the design for the license was, you're looking at kind of the first three A's. Those are really what the board focused on in the beginning. We wanted to make sure that the license would be accessible throughout the state, that would be affordable and academically rigorous. Accessible meant that licensees were able to get the education in their own towns through synchronous learning, which at the time was a little novel, but since the pandemic is pretty routine. It also provide a waiver for a paralegal, a former paralegal like Christy, who has significant amount of education. So someone like that, but could skip a couple of the steps to allow them to become licensed faster. It also, so it was academically rigorous in that each LLLT had at least 45 credit hours of paralegal education. That's things like civil procedure, legal research and writing, those types of foundational courses that you usually see in the first 2 years of like a full JD program. They had to have at least an associate's degree, though many LLLTs have higher education than that. they had to have at least 1,500 hours of supervised paralegal under an attorney, who then signed off on the waiver of those hours. They sat for a paralegal exam and then for a license exam through the Bar Association. And all of this came at a cost of about $15,000 if you look at the cost from, getting your AA and through the practice area courses. And then from the public protection column, I think it's important to think of public protection in two ways, right? One is we protect the public when we ensure that our citizens can actually get to the court system. And then we make sure that we protect the public when they are able to get to the court system through a regulated professional who is licensed, who has financial responsibility, like malpractice insurance, like we're all required to carry. We have IOLTA accounts and must follow the same trust rules as attorneys. And we also contribute to the Client Protection Fund.
The next step in our history of the program is in June 2020, the Supreme Court issued a letter deciding to sunset the program. And in their letter, they identified two areas of concern. One was the overall cost and the small number of interested individuals involved. I will comment very briefly about that and talk about the costs in a moment. The cost to the program, to the WSB, has typically, and correct me, Executive Director Nevitt, if this is wrong, but around $200,000 a year, I think, over the life of the license. It's gone down some since the court sunsetted the program, but it's in our mind a minimal cost to the Bar Association. The other was the small number of interested individuals. In reality, our numbers were growing, and I think Christy or Sarah will identify over the years what happened at the time of the sunset. In fact, the numbers have spiked. And also at the same time, as Sarah mentioned, one of the core elements of our program is to have the education delivered through the community college system. So 32 of the 39 counties are served by the state community college and technical system. And we had, I think, 4 or 5 programs that were involved in delivering that education when the program was sunsetted. And we were negotiating with 2 other community colleges to adopt that program. So our vision, as Sarah said, a LLLT could become a LLLT, stay in their community, get educated in their community, and go back and serve the people of their community. I put this in briefly, I like Justice Mattson, and she wrote a dissent, and she said, I disagree with the court's vote and the way in which it was carried out, which, again, I think Justice Mattson has been a supporter of the license for some time. Go ahead. Is that it? Oh, yes. Well, after that, we adopted amendments to the Supreme Court, just to kind of bring the orders and the rules up to be consistent with the order of the court. And you can review the web page and communication about how this all happened. This slide can be brief, or it can take us the rest of the day. This is here merely to demonstrate to you sort of an organizational chart. And as Kyle, former President Cassetti will explain to us in a little while, there is a division between the kinds of organizations that you oversee. One are the court-appointed boards, of which LLLTs are one, and ATJ board, and you can see the list. By the way, LLLT, we sort of glossed over that. It was a name given to us by the Supreme Court. It means limited licensed legal technician, which we thought was too much of a mouthful. So we scrunched it down to LLLT. And then, of course, all the boards and committees that you're aware of that you deal with all year round in your role. So that's just for your digestion and to understand how we fit into the world that you deal with. Well, we have 87 LLTs currently. And really what that means, there will be 87 LLTs for as long as there are 87 LLTs. So the duty to administer this license will continue so long as people like Christy and Sarah are out there doing good work. Since the sunset, we've been busy about adopting forms. So we're constantly about the idea of making sure those existing licensees are doing the best work they can do and bring them up to date with things that we think they need to know about. And we also carry out the discipline functions in conjunction with Chief Counsel Ende. Fortunately, we haven't had very many of those, which is a joy to me. With regard to the license, I mentioned earlier that originally it was about $200,000. I think, according to this slide, we're now down to about 92,000, and we bring in a revenue of about 21,000, which would reduces the debt that you invest in us every year, and we appreciate your investment.
So an attempt to gather some data about LLT practices. In January of this year, we surveyed the then 88 LLTs that were actively practicing, and we did receive quite a great response rate of 60%. So about a third of those surveyed had been in practice for 5 years or more, while over 40% had only practiced for 2 years. And I think this is indicative of the rush of so many of the prospective LLTs who were in the pipeline to complete their licensing requirements before the sunset in July of last year. And I believe we had accounted for approximately 200 to 400 people who were in the pipeline at the time at the community colleges who had expressed interest in this license. About 2/3 of LLTs have or have had solo firms, and about 20% are currently employed by law firms. 17% also indicated that part of their practice was volunteering through legal aid agencies. Next. So as you can see from this chart, we have it's clear that LLTs have assisted tens of thousands of clients at this point. So the license has been active since 2015. And then looking at the incomes of the clients served by LLTs, 30% of those surveyed indicated that at least 75% of their clients they served were under 400% of the federal poverty level incomes. So we are serving the population that this license was intended to address. Oh, and you'll see that about half of LLTs offer a sliding scale fee, and almost all offer unbundled legal services. 92% participate in pro bono work, which is amazing. And I think that shows the kind of people that LLTs are. We got into this to help the underserved populations. Sorry, I'm having a contact lens problem here. Okay. I keep my own statistics, and so these are my personal statistics. These were compiled in 2022 from 70 closed clients that year. As you can see, about 61% of my clientele have been women, and I think that's indicative of the fact that women tend to be the more financially constrained gender in divorce and family law actions. And the second pie chart underneath there shows the level of my clients as they fall under the federal poverty guideline levels. So 18% of my clients fell below 200%, which would be considered low income clients, and 37% of my clients had incomes above 400%. And I do want to stress, however, that income is not the only factor in clients needing lower cost legal services. versus attorney services. So if you throw in a mortgage payment, student loans, other debts, even if they are potentially above that 400% federal poverty level, they still may not have the ability to hire lawyers. And so having this option is great for them. Regarding ethnicity, I thought the information here was pretty amazing. About half of my clients were people of color. So we are definitely serving that population of people. And then I just provided some information on the types of cases that my clients have hired me for, and approximately half of those cases were divorces. And then the bar graph in blue at the bottom there, I really wanted to provide some information on what my clients were actually paying. And so as you can see, about 70% of my clients paid $2,000 or less for my services. And keep in mind, those can be a number of services. For example, it could be filing the petition for divorce, filing a motion for temporary order. So it's all of that mixed together. So in total, less than $2,000. About 20% paid $800 or less. So I'm a LLT that sets my hourly rate based on a sliding scale, and that's based on where they fall on that federal poverty level chart. And again, I do take into consideration other factors such as debt and supporting other members in their family. So in connecting with attorneys over the years, I've heard chatter where some of them claim that LLTs are charging just as much as lawyers. And I don't believe that to be the case at all, as you can see from my statistics. And I think other LLTs would have similar statistics. Where a common hourly rate for a family law attorney in the I-5 corridor is about $350 an hour. I've seen fee affidavits this year where the attorneys paralegals are charging $180 to $225 an hour. So clearly the fair market rate for a LLT would be even higher than that, logically, because we have the experience and our scope of practice is wider. So I believe that many LLTs keep their rates lower than even the going paralegal rates, because that's our desire to provide services to low-income clients. I'm not in this profession to make money. I'm in it to help the people that need it. And in fact, for last year, I examined what my hourly rate was, and it was my average hourly rate was $136 an hour. And I'm not poor. I'm making a living, and I think that's pretty amazing. So we are definitely not charging what attorneys are charging. You can go ahead. So we're also making an impact in our communities. We have several accolades here. Some LLTs making news in their communities include Leslie Ashley, who was recognized by the Spokane County Bar Association in July of 2021 as a very important volunteer. And then following behind her in with that same award was Andrea Moyer in 2023. Lorena Mendoza was recognized in 2022 by the Benton Franklin Legal Aid Society, as was Mark Von Weber in 2023. And then our own Sarah Bove received the Eastside Legal Assistance Program 2023 Pro Bono Award. And beyond that, many LLTs have held positions in several boards, sections, committees, and work groups, and have provided valuable input from the perspective of self-represented litigants.
So I know Steve mentioned it at the top of the presentation, but everywhere there's a blue link, you can click on it and get more information. We'd really like, if you can, make time. There is a 34-page white paper that was written by Jason Solomon and Noel Smith from the Stanford Center on the Legal Profession, not including the footnotes. It's 34 pages and a fairly quick read. And I think it gives a lot of helpful information and some more details on things that Steve and Christy have shared today. In particular, that they found that LLTs have provided competent legal services to moderate income Washingtonians at critical moments in their lives. They've enabled efficient proceedings and better decisions for the commissioners who conduct pretrial conferences and the motion hearings. And generally, you'll notice there are a lot of quotes from judges, there are quotes from clients, there are quotes from many people who've actually interacted with LLLT. So we really invite you to read that over and get some more information about this license.
So Washington was the guinea pig. We started this all, and there are many other states who have followed in our path since that time. They've established their own licensed legal professional programs. And while those of us living in Washington were the first to become licensed and the first to experience the growing pains of this program, and the trials and tribulations of that, other states studied our program and made tweaks to fit their own state's needs and learned from any, I won't say mistakes, but
Experience.
yes. So both Utah and Arizona have had licensed legal paraprofessional programs for a few years now. And Minnesota and New Hampshire are in the midst of pilot projects for the same kinds of things. Oregon, you may know, they swore in their first cohort of paralegal professionals just last month. And in June, Colorado will be swearing in their first cohort. Other states have or will be implementing similar programs, such as the Community Justice Worker Project that's in Alaska.
Before I get to that, I want to follow up on just one footnote to what Christy just said about other states. Actually, I was on an hour-and-a-half long conference earlier this week with the Indiana Bar, and they're studying vigorously this very same idea. So we can add another one to the list of people that are interested. And not only in the United States, but across Canada. Many provinces are adopting similar programs. And so we're finding it to be a wonderful movement. And along those lines, I'd like to comment briefly. About 3 or 4 years ago, given the rise of interest throughout North America, we started a roundtable discussion. So we, once a month, we have about 100 interested parties, usually Bar Association people, Supreme Court leaders and others who are interested in this concept. And so, again, there's about 100 on our list. We meet once a month. We have a presentation, maybe from a program that is emerging or in the process of adopting, and new programs that are just wanting to ask questions. The forum is designed to just be an exchange of ideas. This is a whole new, as you know, or as you're seeing, a new concept for many jurisdictions. And so it's sort of a petri dish for us to share our mutual experiences with one another. So what have we learned over this period of time? And I think we've learned a lot, and we'll stand to learn a whole lot more in time. For one thing, as a civil legal needs study identified when I began this, my presentation, there are other areas of significant unmet need. And other states have expanded that, and they have gone beyond just family law to add additional areas. So I think that's something that we've learned, that additional practice areas would have been a good idea. The experience requirement, I found it fun to note when in your discussion, I think, about licensing for lawyers, that perhaps an experiential component is a good idea. I'll tell a joke of myself. The first day I was in law office was the first day I opened my own, which is not a very good idea. So we started off at 3,000 hours, and we soon learned through the gracious nudging of the LLLTs, that's a lot. So we thought we could accomplish the same purpose by reducing it. And in fact, I think now we're still more at 1,500 hours than perhaps other states. But we think it's important, in my word, to serve and protect the public. We want these people, and they are highly qualified. And so we want to make sure that the product we're turning out is what the public needs and what we intend to provide. I mentioned the community college system. We think this is a wonderful vehicle for us to be able to deliver services. One thing I learned through the community and technical college system, and we actually had one of their board members on our board, so they could keep us informed about how to navigate that system. But they take an interest in programs in their communities that have an actual need. They're just not teaching philosophy for the sake of teaching philosophy. They're teaching courses that are actually going to benefit their community. And I go back to my comment that, we had 5 and we were soon to have 7 and perhaps even more after that. So that to me was an indicator that perhaps the community colleges saw some value in what we were providing. The mentorship is something that is huge. The relationship between LLLTs and the attorneys and the opportunity, again, kind of like the experience requirement, just an opportunity to learn from somebody who's been down that path before and to develop good skills and good traits. Marketing was one thing. If I were to go back and say, oh, what would you have done differently? I think I would have said, we just need to let the world know what this is. But I think, we both acknowledged and have said that this was the first of its kind. And I often had people say, well, how do you know it's going to work? And I would say, I don't, to be honest, but I think it will. And indeed, I think it has and will continue to. So I would go back and I advise other states who are thinking about this to say, just let the world know. Oregon has been a great example of how to include that element. They've done a marvelous job of introducing their program. Data. Well, maybe data is the biggest one. One of the things we felt as a board that, it's good for us to pat ourselves on the back and say, yep, we're doing the job and we're pretty good people. But, we need some independent third party to be able to say, given what you're trying to accomplish, we think you've done a good job. And I've actually had conversations with Chief Justice Gonzalez. There may be some interest in them doing another civil legal needs study. And I mentioned to him that it might be beneficial for us to include a study of the LLLT program, not only for their benefit, but I think for your benefit. I mean, you're paying money every year to administer this program. And I think it would be prudent for you as fiscally responsible people to know how your money is being spent and whether it's being spent wisely. So I hope someday, actually I've contacted Washington State University to see if they would do a survey if the court won't. So we'll see. But regardless of the status of the program, I think it's something that we need to know, and because it'll make us better in how we tweak our program to meet the needs that we think we're trying to meet. So is that it?
Last one's collaboration.
Okay, collaboration. Well, this has been a wonderful thing because we have had, I think, a good developing relationship. I would like to have created it more formally with the judges, trial judges particularly, because I think they see from the experience of having people like Sarah and Christy in the courtroom that their job is made immensely easier than it had been before when they just had pro se people coming before them, which interestingly enough, and I never thought about this before, but that was an access to justice aspect that I hadn't thought about before. I always think of access to justice as being, I don't have enough money. In reality, when judges have their pro se calendar in divorce court reduced, that means they then have time to deal with the other matters that come before them that have been set aside while the court is dealing with the calendar. So I think it's a win-win-win, and I think judges are feeling that way, at least what we've heard. Oh, well, I don't know if we were running the 35 minutes, but that was a quick run through of where we've been for the last 10 years. And I think I speak for Christy and Sarah. It's been fun. I mean, there have been challenges, but we don't see them as challenges. We see them as opportunities and ways for us to be able to make this a better program, and most importantly, deliver services to people who need them and deliver it in a way that we serve and protect them. So let me ask Sarah and Christy if they have anything more to add, and if not, we'll open it up to you folks. Okay. So, questions, comments? adjourn?
Governor Dresden.
Thank you, Acting President Antreville. Thank you very much for the presentation. I wonder if you could reflect a little bit, given how things played out. And you put some reflections up there, but I just wonder if you could reflect a little bit on knowing what you know now, how you would have gone about it differently, or if you would have gone about it differently. I think, and you can sort of take that how you want to, but I think there are a number of ways in which you could answer that, and I guess I'd like to hear you take it.
Well, I'll take a quick shot at it, and I'm going to turn it over to Christy and Sarah, since they're both board members and probably more knowledgeable about our work than I am. But you know, I pondered that a lot, and I think my first answer, as we both said, is this was the first of its kind. So we were going into uncharted territory, and in my mind, we didn't want to oversell it. We didn't want to say we can do 150% of what we could actually do. So I guess my simple answer is probably nothing. However, as indicated in the last slide, we've learned a lot over this 10 years. So I look at the other jurisdictions that are now adopting these programs, and they look at our experiences, and they call us frequently. We've all spoken to those jurisdictions. And so we tell them the things that they should do differently than what we did, because they'll be better off. They'll learn some things like 3,000 hours versus 1,500. The cost effectiveness of the program, I think there was a disconnect there, whether we were serving middle income or low income people. I think expanding the scope from one practice area to multiple practice areas would have been a good idea, and other states are following that. So, you know, the slide previous to this sort of is our laundry list of things of self-reflection that we've said moving forward. If we can modify our program, and that's whether it's would ever be reinstated or not. That's not the point. We are wanting to make the program as it exists to be as good a program as it can be. So is that too evasive? Right? I wouldn't have changed anything we do. I mean, we couldn't.
Yeah.
I like to provoke.
I think it's kind of like you make a decision. Are you going to put somebody on the moon or aren't you? And I think once you make the decision that we are going to do that, you go full force and you are okay with making iterative changes with lots of feedback along the way. Now, I think that's a lesson we know from this experience, but I do think having that commitment to an idea on the top end, and then quick iteration and lots of social connection and lots, I mean, you touched on it, that like marketing, right? Letting people know what's coming, but letting people know that even this idea has great potential. And if you commit to the idea and you have the support to just push that through, you will make it whatever it is that you want it to be. Right. I think that's probably the biggest difference, is just, you know, once you're in, go all in and bring as many people to the table as quickly as possible, especially people who have a different idea or have a complaint or have a worry. More people you can get in, the better.
So one of the issues that wasn't addressed with APR 28 was measuring the success of the program. And I'm a big data nerd. I keep my own data. I helped to create the survey we sent out in January, and we need to measure the success, and we didn't do that. But I don't think it's too late, and we still can try and measure the success, hopefully with an independent survey in the next few years.
Chief Ende, I think, and then Governor Williams-Ruth, and then Chief Garcia, and then Tom Ahern. So, Chief Ende, you're it.
Thank you, President Angelo, and thank you all for that informative presentation. With paraprofessional licensing programs coming online in a number of jurisdictions now, maybe a small critical mass of jurisdictions, have there been any conversations among those jurisdictions about, say, reciprocal admission or cross-border practice for these types of licenses?
I feel strongly about this, so I'm going to jump in. Yes. There are a couple of things, and that's part of the discussion around in this roundtable. And there's another article that I don't think we referred to here, but there's an organization out of Denver University called ISLES. And ISLES is sort of a national study of the law area. And Christy and I went to a conference there about a year and a half ago, and one of the issues that came up was reciprocity. And it's always been my dream, kind of like lawyers, that a LLLT in Washington could practice in Oregon, which adds portability, which is a great benefit. The other thing, which is seemingly minor, but I don't think so, is the name. We've evolved sort of in a cave along with the mushrooms, and we're kind of growing different mushrooms. But I think we all agree, and that came up at the ISLES conference, was we should have a brand. We should have a way that the consumer in Washington or Indiana or Colorado should be able to say, oh yeah, LLLT or whatever they would be called is a good idea. So yes, I think that's on the radar, and I'd like to see that happen sooner than later, because I think once it happens later, it's going to be more difficult to change.
Governor Williams-Ruth.
Thank you. As someone who outwardly and vocally supports the LLLT program, I'm certain that you are likely aware of the 2021 article from Stanford Law School, the Stanford Center on Legal Profession, called "The Surprising Success of Washington State's Limited Licensed Legal Technician Program." If you haven't read it, you should. And I am sure that our Equity and Justice Chief Officer, Diana Singleton, would be happy to send it to you, as it came to me through our Diversity Council. But it was an interesting read. And honestly, I believe it's a black eye on Washington State and our state Supreme Court for the way they did this. And I was reminded through that article that the decision was 5-4. And I don't mind saying that I am actively promoting it coming back, because anytime we have a 5-4 decision by a Supreme Court, the side in the minority, as we have seen, will spend 50 years to try and overturn it. And I would just encourage anyone that supports this program to talk to our gubernatorial candidates, because, again, if you've looked at the politics of our state Supreme Court and the age of our current justices, and that we have justices that will be forced off due to their age and then be reappointed by the new governor, that the governor of the state of Washington will have a lot of power directly. They can't change a budget. They have to work with the legislature, but they do have the power to impact the court. And so I would encourage anyone that wants to see this program get a new life, such as myself, that you take those opportunities to show up at your Rotary clubs and where the candidates are speaking and bring this up. Have the 30-second, 60-second, I've got your attention for just a minute spiel to help. I mean, again, I am most saddened, and I'll tell you that with my work on the licensure task force, this scares me because of the process that was not followed. And as we're presenting to the court on the task force next Wednesday, I go in with great trepidation, knowing nothing, knowing that they can change their mind without much input. So for those who again, so thank you for being here this weekend, or I guess not weekend, but for being here this week at the meeting and talking with the governors. I'm always happy to see you. And I just, again, I had not been aware of this Stanford Law School article that really paints a picture. So thanks for your work.
Thank you, Governor. Appreciate your support and your comments. And I totally agree about the Stanford article. It was well-written and timely.
Next, we have Chief Garcia.
Hi, Christy covered some of what I was going to say, which is essentially from an administrative perspective, one of the challenges was inability to evaluate the program, right? And that's because we didn't have well-defined measures of success to be able to speak to whether or not the program was meeting what was expected. And different people had different ideas about what the program was supposed to achieve. So I think moving forward for any program being adopted, I think it's a great idea to keep that in mind and have very clear measures of success so we can avoid a similar situation. I was also going to mention the Stanford paper that Brent covered. Thank you.
Garcia. Next, Governor Ahern.
Putting aside things like, practicality and how you're going to do it, how you're going to pay for it, from your experience and keeping access to justice in mind, in the perfect world, what do you think we should do?
I think we need as many legal practitioners throughout the state as quickly as you can. That needs to be attorneys in multiple pathways, and it absolutely needs to be a diversified legal field where there are people who are not attorneys, but can provide these kind of limited service areas. Because that, if you look at, I think the medical field is in a great example. Imagine if tomorrow, all of a sudden, all of the nurse practitioners were evaporated from our state. Our medical system would grind to a halt, and there's no way anyone could afford medical fees or costs, right? And I think that is exactly the kind of what I fear is a crisis in our state if we do not put some kind of affordable program so that people can access the courts. Our legal system is becoming increasingly complex. How many contracts do you sign in a day? Terms and conditions. I mean, just, you know, our legal system is complex. The courts are becoming increasingly complex, and average everyday people cannot access the courts, and attorneys cannot be the only way forward. So I think, how do we get this? How do we get something like this back? Which is your
Just
question.
a question, yeah.
Yes. You know, I think there is a lot of great information from other states. I think we look at issues of reciprocity. I think we figure out a way to allow a legal practitioner, especially in the center part of the state, to have more than one practice area. I'm in a very high density area, right? I can very easily practice in Pierce, Snohomish, King, right? But, and so I have a huge amount of populace that I can serve. I would love to move to the center part of the state. I really would. It's more affordable. It's beautiful here, right? But if all I do is practice family law, my concern is the population density isn't enough for me to have enough clients if all I'm doing is family law to live here and work here. There are LLLTs that are doing it, and they're doing it successfully, but I think they're also having to do things like hybrid paralegal work to make it work. So I think making sure that it works for the center part of the state and being able to meet the average everyday household legal needs is the way forward.
So as I alluded to, there were about 200 to 400 prospective LLLTs who were stranded when this sunset happened. And I would like to reinstate the program, hopefully bring those people back in, as Sarah said, expand practice areas to include housing. We were, at one point, the board was looking into having LLLTs licensed for administrative law hearings. And we had the backing of the chief administrative law judge at the time. And that is a perfect practice area, because right now, many administrative law hearings allow lay people to assist And so we could move right in. And the chief judge felt that we would, us stepping in would fill a niche. I think, we left a lot of those community colleges stranded. And so we'd have to gain back the trust to, to ensure them that this wouldn't happen again. I know from anecdotal experience, there's a shortage of family law attorneys, and they're being, clients are being turned away from attorneys, and we need more other licensed paraprofessionals to fill that need, especially in family law. We can't meet the need.
Since you mentioned family, just one follow-up on the family law stuff, or specialty. How do you, as a practical matter, how do you limit someone who's just licensed to do family law when things go into other areas like, bankruptcy or, real estate or stuff like that? Just as a practical matter, how does that get done?
So you're saying when they have certain issues
Multiple
within
issues,
their
yeah,
family
right.
law case?
Right.
Okay. So APR 28 does have some limitations. For example, with regard to bankruptcy, we have to refer to an attorney if a client is in the midst of a bankruptcy when they're filing for a divorce, and we have to refer to a bankruptcy attorney. They need to get advice from that attorney, and that attorney has to tell us the language that we need to add to their divorce orders to account for that. Some other issues. What are some other issues?
I can tell you in King County, typically most LLTs have a series of attorneys that are in their network, right? That they have relationships with. So I have a client that comes in and let's say they have this like hobby business that's an LLC, and advising on a business is outside of my scope, but it may be an issue in the divorce. So I, had working relationships with those attorneys, and I would say, here's, you can go to whatever attorney you want. Here's a list of folks that I know. They would be able to provide that strict part of the legal services that are outside of my scope, and then come back to me for the family law part. So I think that's another thing, is a lot of LLTs are actually providing an access point to an attorney that they can afford because it's limited, right? And I can handle the breadth of the divorce case. And then, I think for most of us, it's really going to be a business that comes up or something that's outside of our scope. So there's there's property value limits on what we can advise on. All of those tend to be referrals.
Thank you.
And let me supplement that very briefly, just in terms of the process, how we got to where we are. What we did, limited license, important. What we did is we brought in, before we even decided what they were going to be able to do, we brought in experts in the area of family law, lawyers, and said, what are all the things you do? Give me the menu of everything family law lawyers do. And we had them tell us, what are the things that could be problematic, that would be troublesome for a LLT, or more importantly for the client. And so we limited the scope of what we thought they could do. And as Sarah and Christy have said, when they get to the limit of their scope, they're required in writing to advise the client, this is beyond the scope of my authority, and you need to go see a lawyer. The other thing is, when we developed the education component to this, we brought in professors from all three law schools and said, here are the things we want LLTs to be well-trained to do. What do we need to teach them? Help us develop a curriculum so that these people will be well qualified to deliver service in this area. One wonderful comment, one of the professors from the University of Washington Law School who helped us in developing the curriculum, we got to the end of that process and he said to the group, actually, I think these LLTs are going to be better qualified to deliver legal services than recently graduated JDs, because they're taking, as you saw, 15 units of family law. I didn't take one course in family law, and I could, as soon as I got my ticket, screw up any divorce I wanted.
Thank you. And next we have Governor Couch and then past President Dan Clark.
So I wanted to make a note on the reciprocity question because I think it's a good cautionary tale for us as we do this. Steve and I work with a group that of IELTS related people that meets regularly on Mondays and discusses what's going on in the States. And I think one problem we face is a lawyer is a lawyer. Everyone knows what a lawyer is. Every state, you know, is we're starting to reach this critical mass of states doing things, but the problem is it has been an iterative process. And so no state has a program that is like the LLLT program. But they have ones that are trying to solve the same problem. And this, it's funny because each state that has done this says, our hope is to build up a system that every other state can adopt and do exactly what we've done. And each state keeps coming up with their own unique system that they're hoping every other state will adopt. Because they think, and this iterative process is just something to be thinking about as we think about what the future looks like for us, is that at a certain point in time, continuing to iterate actually becomes more harmful to the values of this because you cannot benefit in the same way from what other states are doing, right? If you're not copying them and you're trying to improve on it, trying to change it a little bit. And so that is an issue we face in reciprocity, is if each state tries to build the system that is the best that every other state can adopt, no state has a system that every other state is adopting. They're all kind of doing their own unique things. And so I think as we have these conversations, looking to these other states, what they're doing, what foundation has been made, and stop trying to reinvent the wheel, because reciprocity is difficult now because no state has similar programs. So it's kind of it's an ongoing conversation, but at some point in time, people are gonna have to stop trying new things for it to happen.
If I could real quickly, Christy and I had that discussion at IELTS when we were there, and they really, I think, fall into two different categories depending upon the regulatory process and the education components. And really there are some states, well, we just had a presentation in our roundtable from Texas, and she said, well, we think Oregon or Washington had it wrong because they went overboard on regulation and education. And she said, we're going to define our program as regulation light. And my comment was, and Doug Indy will appreciate this, man, I think we've come full circle to the unauthorized practice of law. I mean, you know, our comment is we want these people to be regulated and qualified and to serve and protect the public. And so we've been very cognizant. And I, at least, Jordan, my observation, and I would ask Christy and Sarah to comment, I think Colorado and Oregon are pretty close to what we are. And I think we could work with them and lead the way to, if we were to be reinstated, to create a similar program to make reciprocity sensible. And I gathered from Indiana when I spoke with them earlier in the week, they very much seem to be interested in Washington, Oregon, Colorado kind of rule.
Thank you. Next, we have past President Dan Clark and then Governor Todd Bloom.
Thanks, Anita. I think it's important to know that there's GR 25 B2E, and that's what the court relied on when they made this license. That's what the court relied on when they sunsetted. It requires that this program be revenue cost neutral within a fair time, within and they failed to do so. So all this stuff that's spoken is great, but they still are not in compliance with this rule. So talk about expansion or to revive it, they still have to comply with this rule. So that's something I've not seen. And we still, I mean, their own slides here, each year they're losing 70K a year. So I believe since it started, we've spent over 2 million that we've had to subsidize. So when we say that the court just acted willy-nilly, I actually find that offensive for the court and for myself, because there was a clear rule that was not met and still not met. So thank you so much.
Is that a question or you want to comment?
Is it a value?
We've got to follow the queue.
Yeah.
So it would be Governor Bloom next, and then you, Treasurer Adewale.
Thank you, Acting President Angeville, and thank you, panel, for the presentation. It was very interesting. I think a lot of us were, had some level of knowledge of the program, but certainly kind of to review it and get kind of brought back up to speed and status and kind of what's going on around the country is certainly very interesting and helpful, I think, for our consideration as a board and organization. I guess maybe make a couple observations and then maybe solicit comments about the comments. It seems like the three focuses on one of the initial slides were consumer protection, domestic law, family law, and the housing law. It looks like, and some of you, at least I guess Christine, had done paralegal work in the past, and paralegals, I mean, are pretty widely utilized countrywide, and in areas outside of this limited practice area. And it's when you look at kind of the rest of the country, what they're doing, it seems like I see the words paralegal or legal paraprofessional are kind of key terms that seem to be kind of in almost all of their descriptors. Certainly, the scope then it would at least appear is much broader with regards to their areas of practice, and that they're not limited in the same way. I mean, it looks like the word limited, it only appears in the Washington program, unlike the rest of the country. And so I find that kind of interesting because it seems like one of the things this allows the LLLTs to do is to have their own form of business and to basically have greater freedom in their economic organization and practice form that does not that other paralegals who are not within these that have the certification, the appropriate requisites to adopt, similar to the LLLTs. And I don't know if there's discussion at the ILE or other organizations that with regards to the breadth or the scope of practice in the other states and kind of how those line up, and whether that that would be a good thing. I found it kind of interesting when you look at the Supreme Court order. It's I thought the wording was interesting, should we say, the order 25700A 1005. In adopting this rule, we are acutely aware of the unregulated activities of many untrained, unsupervised legal practitioners who daily do harm to clients and to the public's interest in having high quality civil legal services provided. Clearly, paralegals or legal paraprofessionals are required to be supervised. There's no office of paralegal of shingles hanging out there, so to speak. The court has found or is stating that there are unregulated, untrained, unsupervised who do harm. But it seems like that kind of the flip side of that coin is that there are legions of paralegals who are supervised and who are actually doing good and assisting and helping licensed legal professionals. And how do we integrate those to the benefit of the public? This also seems to kind of overlay as a potential overlay of the pathways to legal licensure that the task force has kind of looked at, because you've got the experiential component, you've got certain educational requirements and whatnot. And, many of us probably know, and maybe some of us were a paralegal in a former life before going to law school and becoming a licensed attorney. And that's not uncommon either. And that, is this something that could be a stair step or a stepping stone to a licensed legal professional type, licensed attorney type situation. So anyway, those are just some kind of interesting observations that I didn't see highlighted by anybody else really, that are, I thought might solicit some comments or some thoughts that you may have been thinking about these types of things yourselves. So I appreciate the presentation again, and thank you.
Good observations. Good question. And really, your reference to the court order adopting the rule speaks about unscrupulous people. Those are the people that were at that time and still are engaged in the unauthorized practice law. So they're really talking about three different groups of people attempting to deliver legal services, referred to in the order, the unauthorized people practice law, which this issue has been going on as long as the Bar Association has existed. I've looked at minutes in 1930s of, we need to do something about the unauthorized practice of law. Well, the only way to do that is, well, I won't reference today's world, but is prosecute them. And prosecutors have a whole lot more things to do than prosecute people who are trying to be lawyers and causing harm. Paralegals are working under supervision, historically work under the supervision and guidance of a lawyer. So there is presumably protection for the public because of that connection between the lawyer and the client, and the paralegal is doing the work under the supervision and guidance of a lawyer. LLLTs, however, are an independent group. They don't have to work under the supervision and guidance of a lawyer. And that's why they are a much needed component to the delivery of legal services to meet the unmet needs, because they don't have to work under the supervision of guidance of a lawyer, which adds another layer of expense, frankly. So as I've always said, LLLTs are qualified and regulated to serve and protect the public in a way that has not been done before. And frankly, structurally, my idea was one day in a wonderful world of balloons and unicorns that the unauthorized practice law people would disappear because they've been replaced by people who are qualified and regulated and can provide that service at a price they can afford. That's why people go to UPL. They don't have any money. They can't afford a lawyer, but they have a need. And so they say, I've got $50 and or $150 or $200 and I need a will. So they go to the double wide down the street because that's where they can get it. Whereas LLLTs have a good housekeeping seal of approval. They have a license, just like all of us, from the state Supreme Court. That is their good seal, good housekeeping seal of approval. So that's kind of the methodology I think we're trying to deal with. And that's a good observation.
Thank you. We are running a little bit over time, but I'm really happy to see so many questions and such interest in your presentation. What we're going to do is take two more questions. I would ask folks to be as brief as you can be. So that being said, Treasurer Adewale, you are next, and last but not least, will be Governor Rathbone.
I say this with trepidation because I don't want to get into issues between two past presidents of this great organization. But I think we need to cultivate efforts to allow people that disagrees on this program to be able to make their comments without feeling like they are, and I apologize to acting President Sunita, but I think when past President Dan Clark said what he had to say, there is no reason for us to ask whether that's a question or a comment. Because as a supporter of LLLT, I'm trying to build bridges. I think it's very important for us to recognize that our people disagree on this program without being disagreeable. I think we need to try our best to accommodate people and to let people be able to be free to make their comment. So I'm just saying that for us to learn from this conversation this morning. And I believe one of the comment that was made earlier was reference to the medical field. In the medical field, there is a lot of technicians that are licensed, but they are managed by the Department of Health with funding support from state legislation. What past President Dan Clark said is very valid. We cannot rob Peter to pay Paul. we have to be mindful of how we address that concern. A part of our my answer to him is that part of our duty as the Bar Association is to be able to do programs like this that will open the door on access to justice. But I still recognize the fact that it is the bar dues of our members that are paying for these services, for this licensing. And the fact that we have run, we have run high cost on running this program, not down to the fault of the committee that is working on this, to the council, but to the fact that it's a new program that has to be supported. But we have to find a way of communicating that without being, we have to be sensitive to members that are paying to support this program. Please, please, I'm urging the LLLT Council to do a better job in communicating to everyone that this program means a lot. The cost is something, we would, if we need to go to the state legislature to ask for more funding for this, it's well worth it. But let's be very sensitive when lawyers that are paying their dues are asking questions, why are you using my money to support this program? We should not be, sorry, you got my point. Thank you.
And if I could respond very quickly, President Ekawale, I couldn't agree with you more, and I think I speak for our board. We invite critical comment. That's the only way we're going to get better. And so, yes, we'd all love to hear the wonderful things we think we want to hear, but hearing critical comments that help us get better is, I think, what we as a board are all about.
Thank you. Governor Rathbone.
Okay, I'll be quick. So first thing, when this program came out, I think it was the previous predecessor who sat in my position was on the board when this LLLT program was passed. Our office licensed, educated 2 LLLTs. And when the order came down for the Supreme Court, it was extremely devastating to them because they felt like they didn't have worth in the profession, that they worked so hard to achieve a certificate from the Supreme Court, which was the same court that told them they no longer, there will be no new LLLTs. So I want to address that. But in looking at this from my understanding of this program was that it was adopted as a premise for a low bono, essentially to address the access to justice issue in the family law sect, because it's expensive. And so when we talk about low bono, pro bono programs, that cost has to come from somewhere, right? Somebody's going to end up stuck with the bag and paying the bill. So I want that to be on the mind of everyone. But I guess my specific question is, has the board looked into, for example, I think in the bigger counties, King and Pierce, the court employs LLLTs as somewhat of a family law facilitator. So my district is a rural practice. Has the board looked into carving out or finding funding in legislation to open a family law facilitator position in rural courts? So for example, in Grant County, to be able to also address that issue from the court level by employing, I guess in essence, it would be a family law facilitator. But has there been any discussion or any work to try to get LLLTs in our courts?
Yes. Not in a broad or organized way, but frankly, in my neck of the woods, we have one LLLT in Chelan County, and she has served as a facilitator in Douglas County, and has a good relationship with Superior Court judges in Chelan, Douglas, and Okanagan counties. Yeah, I think that's a great idea, and I think it helps use the services of a LLLT. Whether it would be profitable if the license were reinstated, I think there would be maybe at the most 39 facilitators throughout the state, being 39 counties. And it was, somebody may know more about this, but I'd heard recently that there is work now being done to work on the facilitator program. And so maybe this is a time for us to have some input to that process so that they understand the worth and existence of LLLTs. But good question. Thank you.
And that would conclude our time on this issue, but I really want to thank all three of you for coming here and presenting your report. I think it provoked a lot of interesting discussion and debate, and we really appreciate your time. So thank you.
We appreciate the time. Thank you.